All right. Thanks, everyone, for joining us today. We're really excited to talk to you about GDPR, but more specifically, how the GDPR is going to impact those of us in the events industry, in particular as it pertains to audience and exhibitor acquisition. Today's discussion is kind of a reboot of the in-person presentation and session that we had roughly a month and a half ago at the Biotechnology Innovation Organization. The dialogue and the discussion was so good, and it turns out there's a lot of folks out there who had quite a few questions post-event as it pertained to GDPR that we wanted to make it available to those outside of the greater DC area as well by hosting this webinar. And so today's webinar is a joint effort brought to you by Bear Analytics and Vetter Price. So we'll be talking today with Brian Clark from Vetter Price, and I'll introduce him in a second. But just to get through some of the housekeeping items, we will be looking at the Q&A and the question and answer chat box throughout today's discussion. So please feel free to populate your questions there. We're going to do our best to get to them in as real time as possible. Additionally, we have a few poll questions. So we want to take the temperature of the audience and get a sense on where you are in your GDPR compliance environment. It'll help us guide, I think, a little bit of today's discussion as well. So we're trying to make it as impactful for you, the audience, as possible. And I think the most popular question we received so far is, will the deck be available after today's discussion? The answer to that is yes. We'll be shooting it out to you post today's webinar. So with that, just take a second to introduce myself. My name is Joe Colangelo. I'm the CEO and co-founder of Bear Analytics. Bear Analytics, for those of you that may not know, is we're an event data company. We look at audience behaviors to grow and accelerate your event. And joined with me today is Brian Clark. He's an associate at Vetter Price. Brian's specialty is on privacy policy, and there's a number of other things, but I'll let Brian speak to that. So Brian, if you want to tell us a little bit about yourself and the background that you have in GDPR.
Sure, Joe. Thanks for the introduction, and glad to be with you today. As Joe said, I'm an attorney at Vetter Price in Chicago. I've been doing this for about 10 years now. I have a background in journalism, and over the last decade, the media defense bar has, in a lot of ways, shifted into the privacy realm. In part because a lot of the claims that came in on traditional media insurance policies have kind of transformed into privacy claims, and so that's really how I got my start in this area. So what I handle is really the full range of privacy related issues, from privacy litigation, where we're dealing with class action litigation, either related to a breach or related to some sort of claim related to online privacy issues. But obviously, our goal today is to talk in advance and to avoid that sort of litigation. So we do lots of advising on policy work, and obviously right now, as we move toward the May 25th deadline, we are handling a lot of GDPR compliance work and advising, and then we also work on data breach response and incident response management when these security incidents do occur.
Thanks, Brian. Appreciate that. So in terms of the roadmap for what we're going to be doing for today's discussion, we're going to briefly cover what is the GDPR on the next slide here, and then really start the meat of today's discussion is going to be around the impact areas. For those of you on the call, you've also were able to submit a few questions during the registration process. We're going to answer some of those, and then finish up with talking about some resources and materials that are available. But even though we are, as Brian mentioned, so we're 9 days out from that May 25th compliance deadline. I think the tone of today is going to be, it's not too late. There's actually things that you absolutely have not gotten started yet. There's things that you can do to move the needle today, and we're going to walk through an overview on what those tactics and what that approach is as well. So with that, we'll just move forward. And Brian, before we get into what is the GDPR, I just want to take the temperature of the audience. Austin, if you can post the first poll, we just want to get a sense of how prepared the group feels for the May 25th compliance deadline. So if you could just take a second to fill out the poll discussion, I think it'll help us also get a sense of today's audience and where we are in the process as a group. And as we walk through that, Brian, if you don't mind just kind of kicking us off with what is the GDPR, because I know we have the 6 main components up here. If you can just speak to each of those briefly, that would be great.
Sure, no problem. So, as hopefully folks know, by now you've at least heard of the GDPR in some way. It's the General Data Protection Regulation that was passed in the EU a couple of years ago now, but it was passed and then was not immediately going into effect in terms of enforcement. The enforcement deadline that everyone's had circled on their calendars for a long time in the privacy space is May 25th of 2018, which is, of course, 9 days away at this point. Now, the good news I'll give to those of you who either have no idea where you stand in terms of GDPR compliance or feel like you're behind the 8 ball with that deadline approaching. The good news is that in talking to regulators and in talking to colleagues at the Better Price London office who have been dealing with these issues and dealing with regulators on a routine basis, there is not the sense that the regulators are planning to come out on May 26th and start lowering the boom on everybody who's not 100% compliant. First of all, it's because May 26th, I believe, is a Saturday. But second, what they're really looking for is that folks are moving in the right direction. Everyone acknowledges that this is a difficult process. It's a complicated process. And the other factor is that there are so many companies that, at least in theory, are subject to regulation under the GDPR that, they most likely are going to be targeting, kind of the big fish first, and to see if the big entities are really doing what they should be doing with the GDPR. And then more realistically, the smaller entities that are more likely to get scrutiny early on are going to be those that are unfortunate enough to have a breach involving European data, right out of the gate. So with all that being said, anything you can do to get moving in the right direction is still better than doing nothing. So what are we trying to move toward? What we've got up on the screen now are kind of 6 high points that, if you were hitting all these areas and at least moving in the right direction, you would likely you put yourself in fairly good stead with the regulators. We're looking at privacy by design. That's going to be something that you're going to need to implement in your company and just use moving forward. It's not necessarily something you can do right now, but basically the idea there is as you are designing systems going forward, you need to be thinking about how they affect privacy. I think rather than what a lot of companies have done historically is they put together their systems and their plans and then they think about privacy later. The European model is now to change that and have privacy be front of mind as those things are being put together. So that's more of an ongoing issue. One thing that people can and should be focused on, as soon as possible, is the issue of consent. And for an American audience, the way the GDPR thinks about consent is often a bit different than how we deal with consent. It's not uncommon, and in fact, it is common in the United States to adopt a privacy policy and terms of conditions that are linked off of your homepage, and those terms and conditions that people may never visit say that continuing to use the site means that you agree to all these various terms, including whatever the privacy policy says that they are going to do with your data, and by not opting out, you are essentially agreeing. the while that's acceptable in the United States to some degree, that's not acceptable in the EU, particularly under the GDPR. What they are looking for is an opt-in model for instances where you need consent. Now, there,
So Brian, on that, if I could just chime in for a second, because that's a
Yeah,
great point, and we got
absolutely.
a question pertaining to, I think, exactly that point that you made, and I just want to make sure it's straight in my mind. So we had someone before the event type in, I think, a very good question, which is, if someone is attending one of your events, so they're going through that registration process that everyone pretty much has to go to, is it considered implied consent if they register? And I think what I heard you just say is, no, it actually has to be something more than that. We're changing the name of the game in that regard. There's no more just because you gave me some information, I can now go back to you and talk about other events. I have to do more. We have to be more explicit. Is that correct?
Well, so let me give my best lawyerly answer of it depends. Yeah, so there's a few aspects of the GDPR. To the extent that you are collecting, if someone comes to your site, and just to boil this down to the simplest analogy possible, let's say that for them to register for your event, you need their name and email address so that you can then send them information, about when the event is taking place, and whatever other information they need related to the event. You likely would have a justification that would be, the mere act of them coming to your site and providing you with that information. You could argue that is a necessity or even a contractual relationship, and thus, to the extent you are reaching out to them and using that information only for that purpose, then that may be enough for there to be consent in that context. But we all know that in the event planning space, a lot of that information is at its most valuable when you can use it in other ways, whether it be marketing for another event or allowing sponsors to market to those individuals, etc. That's where it really becomes essential to have an affirmative opt-in when you're dealing with EU residents. They are not going to say that an implied opt-in is not going to be enough. They're going to want to see that there was some specific language detailing what you are going to do with their information, and that they specifically opted into that use of their information for them to consider it to be valid consent. So
no, that's helpful. I appreciate you kind of walking us through that. In terms of, if we're kind of working our way around the chain here, we had a couple of questions come in specifically around the right to be forgotten. That seems to be a new concept here in the U.S. Kind of being a little bit on the tech side, I can tell you pretty much every database now is designed with a soft delete. But I think what we're asking for here from our technology providers and partners is that there needs to be the option for a hard delete. So there is no archive recycle bin where the data can be brought back. We need to get rid of it once and for all. We're trying to actually delete, files and records of folks.
Right. Yeah. So the right to be forgotten is, a very, as you said, a very foreign concept to American companies. But what this basically allows is for an entity to come to you and say, forget we ever talked, forget I ever existed, delete me from all of your systems. I don't want to ever hear from you again. Now, that's generally how it's described, and that's because that's the easiest way for it to be understood. And yeah, as you said, they are looking for more than a soft delete. This isn't just take me off your list. This is, remove me from your database, which obviously makes it more complicated. That being said, there are a number of exemptions to the right to be forgotten. So, as you look at this, it's important to either review those exemptions or go over it with counsel to see which of those may apply. For example, if it's a entry that is tied to an existing contractual relationship, or it's evidence of the contract itself. So, for example, certain transactional data, you may not be required to delete that because it's actually, reflecting a transactional history. So, again, you'd want to evaluate that on a, not an individual case by case basis, but on a company by company, category of data sort of basis. Or another example I have, and not so sure it would apply here as much, but we have had clients that are in the research industry that say, well, wait a minute, we got this data, we incorporated it, we performed individual services, but then we also, with their consent, incorporated it into a broader research study. Are you now telling us that we have to go back in and alter our research, analytics to, pull out that one piece of data? And the answer to that is no. There are exceptions within, the GDPR related to research studies and things like that. So, that's generally what the right to be forgotten is looking at. And then, more specifically, then, you need to, for your company or your event, take a look at those exemptions and see if there's any of those that you can avail yourself of.
Hey guys, I got a question here from the audience. Jonah asks, do you have to break down the opt-ins for how you share data with exhibitors and sponsors within registration? For example, we do pre-post-show vendor emails that we push for them and do an opt-out for that. We also put it in our terms and policies around how we share info with paid sponsors, exhibitors, and they have to accept those terms.
Yeah, so this is a common question, and the unfortunate short answer is yes. As far as the GDPR is concerned, if you have EU residents who you are wanting to include on those sorts of emails that you're sending out pre or post event, promoting sponsors or giving that information to exhibitors, etc. Under the letter of the law, under the GDPR, you'd need to get a consent. Now, how are people handling that? There's a lot of different ways. And it can range from we're just not going to do that anymore to we're just not going, anybody who tells us they're in the EU, we're going to bump off of the email list. Or there are folks who are affirmatively getting that consent at the time of registration, that they're adding in a second line that says, to receive information from our sponsors, click here to provide your consent to receive an email to that extent. And that is, so that's how, there's different ways people are approaching that. But the short answer is, just, you can't presume intent just based on the fact that they're researching or that they are registering and not opting out.
So that brings up a good point. It sounds like that there, as we kind of navigate here toward the next slide, and we talk about what is the spectrum of options that an organization has in order to maintain compliance. So all the way down at the bottom, you can see you can go ahead and do nothing, and that's largely a dice rolling exercise. But there are a couple options at the top which all get you to the point of compliance, and I think they speak to Justin's question here on the Q&A chat, which is there the opportunity to be compliant, but then also, because we want to be able to do analysis around the EU folks, I think it pertains specifically to that middle option. Can we just anonymize the EU data, that transactional data, so that we can know, how many folks, for example, from each EU country we have, but we don't actually have their personal identifying information attached to that?
Yeah, so that's a great question, and this is one of the things I find myself saying a lot with regard to the GDPR and any sort of compliance exercises. There's really a continuum of compliance to consider. I mean, obviously, as counsel, we can go through and tell you, the letter of the law and the most compliant things that you can do where you'll be 100% safe. But we also realize that certain companies are willing to take on greater risks than others. And, there are also things that, particularly when you're dealing with something like this, if you have a company that has a very small EU presence, or, it may not make business judgment sense for you to, completely change the way your company handles data, just to make sure you are 100% GDPR compliance. So there are levels, and of course the risk rises. So if you do nothing, if you continue now just like you always have, and you say, we're just going to roll with implied opt-ins and whatever, theoretically you could be fine, because it will really only ever come up if a regulator or a EU resident wants to challenge your compliance activities. But there's obviously an increased risk, and should a regulator then come calling and it's revealed that you've done nothing, they're much more likely to levy the heaviest penalties they can, and those penalties under the GDPR are potentially very substantial. But looking at these, and I'll note that 40% marker on the side is just kind of a visual aid. That's not to say that a passive opt-in is 40% compliant. that number could be anything. But what it means there by a passive opt-in starting today is you could say, well, okay, we're going to take, we realize, because what we're looking at here is what do we do with the data we already had? What happens come May 25th to everybody who already opted in? Are we grandfathered in? The GDPR says no, you're not. The GDPR applies to all data you've ever had related to EU residents. So if you have, just using round numbers, 1,000 EU residents in your database that opted in some way in the past, you need to go back and look at that. And if that opt-in was not GDPR compliant, which given how strict the GDPR is, probably it was not, you then have to decide what you're going to do with those folks. So, there's the do nothing option. There's the passive opt-in, which would be, look, we're going to leave these people in our database, and we're going to take the risk that, now we're going to put up a GDPR compliant opt-in on our site for everybody who comes to our site after May 25th, and we're going to hope that they then subsequently opt in. And so we're kind of just going to try to capture them that way and hope it never comes back to us. Again, there's a lot of risk with that. But, it's less invasive. Now, then we go to the other options, all of which would be compliant, but obviously have different pros and cons. The top option is something I assume that almost no one's going to want to do, but it's, again, using that hypothetical where you have 1,000 EU residents, delete them, start over, pretend they were never there. That obviously is not good from a marketing standpoint, but from a privacy standpoint, it's hard to argue that, with that being compliant. The question that was originally asked here that got us onto this topic is anonymization, and that's a great question, and that is a way to work around this. If you are dealing with historical data that you don't want to do actual outreach anymore, but you do want to have some sort of analytics to run, to gather information about, how your event went, what specific areas, you should be targeting, maybe industries, things like that, and you're able to anonymize the data. If done properly, that would be a way to be compliant, because what the GDPR is focused on is personal information. That's information that can be used to identify someone. It's a bit of a, it's a broader definition than, the term we typically use in the United States is personally identifiable information, and that has a fairly specific definition. In the EU, it's going to be broader, so things like name and email address are going to be enough. But if you're able to anonymize that and just say, we had, just for an example, someone from England, someone from England in the, business to business office goods space attended our last conference, and, that's useful information for you, but it's anonymized, that's going to be sufficient. And then the last thing, and this is what a lot of companies are choosing to do, but it is complicated, and, it is, particularly if you want it done by the 25th, obviously you're really at this point starting to be up against the time crunch, is confirm via a new active opt-in. The term that's sprung up around this has become re-permissioning. And basically what you're doing at that point is reaching out to everybody who's already in your existing database, who you know is in the EU. So for example, again, using that hypothetical of the 1,000 people, you're going to send them an email now based on your existing, based on your existing consent that you have, because the GDPR doesn't apply yet. And you send them an email and say, hey, and I've seen it done in varying ways. Some people have come right out and said, hey, you're getting this email because of the GDPR. We want to get your new consent to continue communicating with you. Or are we good? Click here to consent. Other people have done it in a more vague way, but still, adequately addresses the requirements of GDPR consent, such that when somebody gives them the click, it's an affirmative consent. But basically at that point, you're getting a new consent for all of those individuals that is GDPR compliant.
So in that vein, thinking about the re-permissioning, Austin, if we can put up the question we have about how many folks have implemented those types of campaigns to date, I think it would be good to take the temperature of the audience to see where we stand there. So as you fill those out, Jennifer also asked a question about what happens with folks that are registered prior to May 25th. So if I'm reading into that question perhaps a bit more, if there's an active, because you talked to Brian about what to do historically, and that obviously, there's a big bucket there from a re-permissioning standpoint. But what if there's an active registration process open, and the registration window rolls over that May 25th deadline? What is someone to do in that scenario?
That's a definitely a tricky situation. I would say that if it's something that's already started, obviously it's more complicated. If it's something that's just about to kick off, whatever you can do to make that registration process GDPR compliant starting now, there's no penalty for complying early. So if there's a way to go ahead and get those GDPR compliant opt-ins, or address the presence of EU data subjects in some way at the outset, that would be ideal. Again, it gets into it ultimately gets into a question of the risk profile, and how many EU data subjects are we dealing with. Under the letter of the GDPR, they would say, well, as of May 25th, even if they just registered on the 24th, if your opt-in was not GDPR compliant, then they haven't actually opted in, and you need to be very careful how you're using that data. Now, again, that's not to say that it's impossible to use any data, right? So, I mean, going back to the potential other legal basis for processing information under the GDPR, if you're putting on an event and someone has registered for your event, and it's necessary for you to send them an email to tell them where the event is, that's a necessity argument that that there is not a need for specific consent. But if the goal, as I imagine it often is to use this as a tool for marketing for other events or future events, or sponsors, etc., you're going to need to take a careful look at that data set and the nature of the consent, and if possible, perhaps pull the EU folks that have registered before the 25th, or at least make a calculated decision amongst yourself and your sponsors and whoever else might be using that data, to say, hey, there's only 5 EU residents. How do we want to do? Do we want to email them again and get a new opt-in? Do we want to roll the dice? Do we just want to remove them from the list? Still able to come to the event, but just not on a marketing list. So, you'd have to figure out how you want to handle that.
So moving from the planning into more of the actionability, I think, again, putting there's 9 days left kind of hat on, with the group that's on today's call, We covered a number of these boxes earlier in terms of what can be done today, but I think the big one here that we've kind of yet to address that speaks to some of the questions we received pre-reg and then some of the ones that are in the feed currently is the data map. So if you can kind of just take us through, what should the group be looking at over the course of the next 9 days, especially that bucket that said, we don't feel like we're really in a good compliance space. I think it was somewhere in the 60 percentile of those on the call. Where should they be focusing their activities for the next 9 to 10 days?
Sure. Well, and I guess I'd start by saying, for those who do feel like they're in that position, you should know that you're by no means alone. I'm working with several different clients on moving toward GDPR compliance. And even though with all of them, we've taken, big steps toward being compliant, I don't know that any of them are, feel 100%, that they've definitely got everything locked down, just because companies today, there's so much data that flows in and out, and there's always a question of, have we actually identified everything and addressed everything that we need to address? So I think even some of the biggest companies out there are, they may show outward signs that they're very confident, but there's always probably a concern in the back of someone's mind. And as I said, the reason for that is because you're always concerned that there's another source of data lurking somewhere that you haven't addressed. So the data map is something that we generally do as a first step when we're helping clients with GDPR compliance. And the goal here, and it's also something that ultimately is required by the GDPR. So it's both a good planning tool, and it's then you have it in your file after the fact to document that you've taken those steps. Is you basically you're going to want to go through and determine what data you have, where does it flow from, and what do you do with it. And inevitably in this process, we have multiple meetings with multiple stakeholders, and we think we've identified everything, and then we talk to somebody else and they say, well, what about our web tracking data? And then you find out that, well, okay, everybody who comes to our website, we also collect their IP address. And under the GDPR, the IP address is arguably personal information because it can be used to identify where someone is. So, okay, well, now we need to figure out how we're going to address that. And then you talk to somebody else, and they say, well, when we send out our marketing emails, we send that through a mail vendor, and so we provide all of the email addresses to that mail vendor to send that out. Is that something we need to address? And so you work through that process and you identify everything, and then you can really start to build out what your policies are going to be, and whether there are any practices that you need to restructure in order to be GDPR compliant, in order to make sure you're getting the necessary levels of consent. Generally when I do this, it ends up being kind of a Excel spreadsheet or a chart where you've got what's the category of the data, what is it, where did it come from, how is it stored, is it stored on our servers, is it stored on someone else's servers, is it encrypted, all those sorts of things. Who are we sharing it with, what's the business function of this data, what's our justification for having this data? Is it a necessity issue? Is it a consent issue? Is it under what part of the GDPR can we justify having this? And you're able to build that out, and that then creates a roadmap for you to look at the areas that you need to be targeting in terms of either changing policies or getting consent in place and things like that.
So I think you hammered something there on the data map piece, Brian, and looking at an individual's IP address as a piece of information that would be able to, identify where they're from. We have a number of questions in the feed talking about cookies on a website. So a couple of the different applications there being using cookies to track an individual for a better user experience.
Right.
And so talk a little bit about what needs to be done from a cookie level, because that's, I think, part of the that's a little bit more behind the scenes than actually filling out a registration form.
Right. So so this is an issue we've addressed with several clients, and I'll say that, you know, as a key starting point, I'll make a distinction between and I bet this will lower some blood pressures. You know, a distinction between using cookies and collecting IP addresses. You know, the traditional, you know, static cookie that most websites use, you know, or at least historically have used, is, you know, a line of code that creates a clear object that sits, you know, on the computer of the end user, and basically allows that when they come back to your site, as you said, it maximizes their experience by remembering certain things about them, and, you know, basically it interacts with the website when they come back. Those types of cookies, you know, at least with how they've been used historically or by the clients that we've dealt with, it's all putting information out there for, you know, onto the end user's machine. It's not that you are collecting information on the back end for you, the company, to have about that person. So to the extent that you're just placing the cookie and you're not getting any information back about the individual unless or until they come back to the website, you know, that's not necessarily a collection or processing of personal information that would need, you know, to be addressed in some way under consent under the GDPR. You know, now there are European regulations related to cookies that have been around for several years at this point. That's why if you go to a website that is either based out of Europe or has a significant European presence, you'll often see on the front page a pop-up that says, hey, this website uses cookies. You know, for more information about cookies, you know, you can click this link, and if you don't want to have cookies, you should leave the page, or, you know, what have you. So that's common there. And that could be, depending on how much contact your company has with Europe, it could be something you need to work with, but it's not necessarily a GDPR issue. Also, I would say if you are a US-based company, unless you have a significant European presence or you have content on your website that is specifically directed at a European audience, you probably don't need to worry about those cookie regulations. You know, now if you tell me that you have a separate version of your website that is in Italian and has a .it you know, domain name, then we should probably talk about your cookies. But you know, if you're just a US-based company with a US-based website that, you know, can be accessed anywhere in the world but is not specifically targeted at Europe, you know, your cookie situation is probably not an issue. Now, I will distinguish that from a situation where you are running some sort of software on your website that every time a user comes to your website, you capture and store and maintain and do something with their IP address. And again, to distinguish, I'm not talking about Google Analytics or any other sort of, you know, general website analytics that are anonymized and just tell you, hey, you had, you know, 500 hits on the website yesterday, and here's the general geographic breakdown of where they came from, and here's the websites they redirected to, and here's how long they stayed on the website. Because again, that's not personal information. But if you are collecting and holding on to the actual IP address that could theoretically, you know, if traced back, tell you exactly where that person was sitting, you know, in the world, that's when you start to potentially run into GDPR issues that you would need to look at what you're doing with that, why you're maintaining it, and, you know, whether or not you need some sort of consent for that, and then frankly whether it's even possible to get consent from that, because frankly a lot of those programs, as I understand them, run automatically as soon as someone visits your site. So even if you had a pop-up come up, you would have already theoretically collected their IP address. So that's the distinction, and that's how cookies play into it. So I'm hoping that helps with some of those questions.
No, thanks for that insight, Brian. I appreciate it. We had a couple other questions kind of boil up in terms of repermissioning again. So what are some of the tactics in your experience that you're seeing organizations use to determine if someone is actually from the EU? And then from there, if you're going through the repermissioning exercise and sending them an email, what happens when that email, if and when that email falls on deaf ears and those folks aren't responding?
Right. Okay. So the first question, and this is a question, that everybody has struggled with, is, how do you decide if someone is, in the, an EU resident, or an EU citizen? The last thing you want to do is, actually, because generally what you have on people is name, address, email address, something like that. And you may be able to infer some information, but you probably don't actually know whether they are, a citizen of, whatever country their address is based in. And you certainly don't want to ask that question, because then you're just actually collecting a further data point that's arguably more sensitive than the information you already have. So the general rule of thumb that we have suggested that people follow, and we think is reasonable, that regulators would also probably find reasonable, is if you have an address for someone that's in Europe, or for whatever reason, even if you don't have their address, if you have reason to believe based on what company they work for, or whatever reason you believe they're in Europe, our suggestion has been to treat them as a European resident and apply the GDPR. Similarly, if you have a individual who's in the United States and their address is in the United States and you have no reason to believe they're European, unless you want to go to the extent of essentially making all of your data, basically either repermissioning all of your data, or going forward treating all of your potential registrants as if they are from Europe. If you have address information and it's somebody who's in the United States, it's reasonable to proceed as if they are American. Obviously, that's not a perfect system. There are going to be times where you hit people in Europe who are not European. There are going to be times where you hit people in the United States who are from the EU. But at this point, that's a reasonable approach, and we think that the risk factor there is fairly limited. Now, the second question was, what happens if you send out a repermissioning email and they ignore you? Or I'll take it a step further. What if they say no? Because essentially the way the EU regulators would look at that is they would say, someone who ignores you, that is a no, because you have to have an opt-in. So if they haven't opted in, then you should treat it as if they said no. Now, this is again a place where you have to make a business judgment as to how you want to handle that data, because it is data that you've had previously, you've kept it, obviously it's valuable to you in some way. The letter of the law would say, they haven't opted in, we have to treat it as an opt-out, we better delete them and hope they come back at some point. There could be a reasonable business decision made to keep that data for some purposes, whether that be to anonymize and analyze it, or to keep it but remove them from certain lists. It would really depend on exactly how you're using the data. It would definitely be creating a risk of GDPR noncompliance, but that's something that each company has to assess for themselves.
So speaking of tools and tactics and how folks can get into their own organizational assessment, let's get a little bit away from the Q&A. We'll get back to it. I'm hoping to have a couple of minutes at the end of today's discussion, but I want to make sure we have enough time to go through all the content here. So getting into the idea of a gap analysis and what can be done if folks had to absolutely get started today. Take us through this, Brian.
Yeah, so the idea here is just trying to see what you have in place right now and look at, where the gaps are. The information audit largely mirrors the data mapping exercise. As you see here, I won't read the slide to you, but it's basically the same information that we were looking at before, which is, where's the data and what are we doing with it? Because all of that's essential information to know then how you're going to manage the data, because you never know what you're going to find, in terms of how people are collecting data. We've even had instances where we've had clients say, well, of course, no, we wouldn't. I mean, not even in GDPR context, just, this often comes up in the data breach context is, well, we wouldn't have any PII because we never collect people's social security numbers. And then you talk to someone else and find out, oh yeah, we actually have hundreds of social security numbers in this spreadsheet. So, it's things like that you need to make sure you understand what you have before you start formulating your policies. Then moving over to the policy and procedure audit, you're going to want to look through what policies and procedures you have in place now and determine whether or not they are, GDPR compliant, whether or not they need to be modified. And, I can tell you from having gone through this exercise with varying companies of varying sizes and sophistication, there are some that we have just needed to make fairly minor modifications to, basically just update some information about consent. And there have been others that we had to draft from scratch new policies. Now I'll put on my litigator hat for a minute here and say, anytime you're talking about policies and procedures, I always say to clients, policy and procedures are great as long as you're going to follow them. So the last thing you want to do is, and we've seen this time and again, and this is something I would particularly warn against as people look at this 9-day deadline. I would discourage you from saying, well, I want to make sure we've got a GDPR compliant policy in place. So we only have 9 days. So I'm just going to grab one from somebody who's like us, that I find on the internet and swap out the names, and that's our policy. Because, particularly from a litigation standpoint, or if you're ever in litigation, or if a regulator ever comes knocking and you have a policy in place, but it doesn't actually mirror what you're doing, that's actually worse than if you just had no policy in place. So you want to be looking at those policies that you've got, look at an incident response plan. One of the things that, we didn't get a chance to touch on the last slide, but this is one of the areas of alarm for a lot of people in the industry about the GDPR, is it has a 72-hour requirement for notifying regulators about a data breach. If you've ever dealt with a data breach, you know that is a astonishingly short period of time, and very difficult to comply with. And so ideally you have a incident response plan in place, and you've got everyone lined up so that you are not, should there be a data security incident, you're not first trying to figure out what the plan is and who's going to be involved. You can jump right into it and take the steps that are necessary. Looking at employment and recruitment procedures. Who are you hiring, and what are you requiring of them? Who are these people that you're giving access to? With regard to your consents and your disclosures, how are you tracking those? Your consent language is great, but if you can't prove that anybody ever actually visited that website and clicked on the box, then you might as well not have it. Communication monitoring policies, or are you making sure that information is not being sent out the door? What policies do you have in place regarding to the deletion and transfer of data? We've talked about the right to be forgotten, but the GDPR contains a whole bunch of rights for the individual, the right to access. They can, say, hey, I want to know what information you have about me. The right to correct their data. They can say, hey, I think you have my wrong address. Can we get that changed? There's the right to be forgotten / deletion. And then there's also the right of portability, basically that they can, have the data transferred to another company. So, what policies and procedures do you have in place to deal with that? And then once you've got all those policies and procedures squared away, then it becomes a matter of training your folks internally to make sure that you've, are getting them up to speed on all these issues.
So narrowing it down specifically to the folks on the phone, event organizers, event marketers, people that are in charge of audience acquisition and exhibit sales. We've touched on a number of these, but as I look through comb through the questions, there's some discussions about not just outside of registration and moving into the exhibition space, but also looking at the tracking on site that's done. So emphasizing that fourth bullet on the left-hand side is other vendors that are involved in tracking an attendee, their actions on site, whether it's going to an education session, walking the exhibit floor, lead retrieval, scanning badges, any of these types of tools. What does the audience need to know on how to get ahead of the GDPR compliance as it pertains to some of those technologies and some of those vendors?
Yeah, it's complicated, and there's a whole host of issues. Probably that we could probably spend another hour on that fourth bullet point alone, because those are such complex issues. I'd say just two big high level points is one, just to circle back on the general premise of the GDPR. The GDPR is all about full disclosure and transparency. So, when in doubt, anytime you have something that is a type of tracking or targeting that is likely to be happening without people knowing that it's happening, that should set off a GDPR red flag for you, because the European regulators would likely think that's a problem unless there's not explicit consent given in some way. And then two, I would say for all these entities, they should be aware of the GDPR as well. And so, when you're having your conversations about having those vendors and those sorts of tools at your event, when you're in those initial discussions, specifically say, what is your GDPR plan? Like, how are you dealing with, tracking and beacons and retargeting in the context of the GDPR?
Thanks. So let's move over to the other side of the slide here, talking about exhibition sales, because largely we've been focused on that kind of B2C relationship, if you will, going after the registrant or the attendee. There's the whole other side of the house that for majority of event organizers needs a lot more from a revenue standpoint and a relationship standpoint, that kind of B2B exhibition sale. So if walking through kind of some of these questions, what does happen when you only have a few folks that you may have a relationship with, but it's an important client to you from an exhibition or a sponsorship standpoint? Those both go hand in hand. I probably shouldn't just be saying exhibition sales. What happens when you potentially can't re-permission or don't have permission for that particular individual, leading to, again, a bigger sale?
Yeah, so it's it's obviously a difficult scenario, and it's frankly something that I don't think the regulators have necessarily thought through the implications of everything that they have set forth in these regulations. One thing that we're recommending to people is, once you have that initial contact, once you've got the opt-in, try to make sure as quickly as possible that you're introduced to other people there as well, and that you get that dialogue and kind of approval going for them. The other thing, so that if you're one person from opt-in leaves, you have something else. The other thing is there are potential ways to, legally process the information under the GDPR, without there being consent. So, for example, if you were already involved in a deal with one of these companies, and then your contact leaves, well, you have it's a necessity for you to continue being in contact with that company for you to proceed. The other factor that we've talked about a lot with clients is, what I call the business card scenario. I arguably, read literally, they would say, those regulations could mean that, you're at a cocktail party, someone hands you a business card, but you can't then send them marketing material unless you whip out a consent form when they hand you the card and have them sign it right there. Obviously, that is not a thing that's happening, and nor would I think a regulator would even tell you that was required. So we're generally, trying to, in that sense, just try to employ a common sense approach. If it's an entity that you've been already engaged in emailing with, as relates to a specific deal or event, and you can find a email address for them online, it's probably reasonable to email them without getting some sort of express written consent. But if you're about to send out a marketing blast to, all of your clients, and one of your client contacts just left, you might want to think twice before just swapping that client contact out for somebody else.
Awesome. And as we approach the top of the hour here, I'm just going to kind of go through and make sure that we're able to touch on best practices for the sales and marketing efforts. I think we did a really good job in today's discussion of talking through, with the help of some of the questions, about the benefits of anonymizing the transactional data. You kind of have the best of both worlds if you're not able to re-permission, again, being kind of 9 days out at this point. We touched a little bit on how you can get and generate those new leads. It really starts with, I think, for that data map, going back and understanding where the first place you're getting those new leads, where they potentially could be hitting, and having those defined protocols and opt-in and consent language in place so that you're able to convert at those that point of data acquisition. Just a little tidbit in terms of what we see from a Bear Analytics standpoint and our clients in the industry. We're largely a U.S.-based organization, so in terms of the EU influence, it's somewhere in 5 to 15% for the average trade show that we work with. So we just want to encourage you to keep that in mind when you're trying to assess the impact. Obviously, we're only looking at it through the event lens here. If you're a membership-based organization, there's a number of different other quote-unquote lenses that you're going to be counting on and looking at. And then I think an important point, and we've kind of touched on it, but we didn't say it explicitly, is really work with your event vendors. Certainly there's some really proactive folks in the space who perhaps are a bit ahead of where you are as their client in terms of the GDPR and compliance, especially those that are more heavily on the technology side. So having strong vendor alignment can really impact those sales and marketing efforts. And then getting into where we can learn more. Again, we will be providing this deck afterwards, so you don't have to remember these URLs, but there's some additional privacy risk reports that are available. We have the official GDPR website if you care to read up on it with additional context on each of the GDPR-specific elements. So thanks for providing those for us, Brian. And with that, I know we're at the top of the hour, so I just want to give a big thanks to Brian for being with us today, walking us through today's discussion, helping us answer questions. I know we have a couple left on the table here. We'll do our best to get to those in a one-off basis, but we will be providing the deck. Thank you all for participating in today's webinar. Again, another big thanks to Brian. We hope that you're able to get into a better GDPR compliance space within the next 9 days, and continued success for all your events. Thanks very much.